Good afternoon. I am Andy Cooper with Environmental Consulting and Technology Incorporated, also known as ECT. We are a consulting firm with 22 offices across the United States, and I'm based here in ECT's Chicago office. We're excited to have so many of our ECT team and colleagues join us for this first of a 5-part lecture series, which we are hosting throughout the month of October 2020. The theme for the series is based on the business of the environment, and it will cover a basic overview of the underpinnings of environmental regulations within the United States. This first lecture is titled The Legal Basis for Environmental Regulations. Upcoming lectures include the Federal Clean Water Act, Toxic and Hazardous Substances, the Federal Clean Air Act, and finally, Protecting Wildlife and Preserving Biodiversity under the Endangered Species Act. In terms of housekeeping, we're all becoming very familiar now with the importance of muting our microphones, so please be sure to mute yourself. The session will last a total of 1 hour. The first 45 minutes will be a presentation format, followed by question and answer period. You're encouraged to type your questions in the chat box, and we will facilitate the Q&A at the end. Just so everyone knows, these lectures are being recorded and will be made available afterwards. Our series speaker is Mr. Mark Richardson, an environmental attorney with over 30 years of practice, including 8 years as assistant prosecuting attorney for water quality in Macomb County, Michigan. Mark currently maintains a practice in Berkeley, Michigan, specializing in environmental and land use law. He's also an adjunct professor of environmental law at Oakland University in Southeast Michigan. ECT's relationship with Mark began in the early 2000s when he was the chair of the Clinton River Areas of Concern Public Advisory Committee, working with ECT's Water Resources Service Line Director, Dr. Sanjeev Sinha. Mark led cutting-edge work developing expansion targets and prioritization of habitat restoration. He is also on several ad hoc committees, including the Southeast Michigan Council of Governments, the International Joint Commission, and Michigan's Department of Environment, Great Lakes, and Energy. Welcome, Mr. Richardson, and thank you for joining us this fall. I will now turn it over to you.
Well, I appreciate your very generous introduction, Sanjeev. Before I begin, I'd also like to extend my thanks to Marcia Harrison and Andy Cooper for doing everything they can to make my presentation presentable. I owe them a lot. Next slide, please. This lecture today is going to be in the nature of an overview of the building blocks, if you will, of environmental law and regulation in the United States. It's going to be part civics lesson, part examination of recent changes, particularly in the National Environmental Policy Act. I'm not going to be able to get into too many specifics due to the breadth of the subject matter, but this is to provide a foundation for the next few lectures, which will be more narrowly focused and have more specifics in them. What are what's the legal framework for regulating the environment in the United States? Environmental regulation is a recent phenomenon. It's really only about 50 years old, but the legal roots extend far back and actually shape the nature of the regulation that we have. So I'm going to be talking about, first of all, the separation of powers between governmental units in the United States. And then I'll discuss the limitations on those powers vis-a-vis private individuals and private activities. From there, I'll switch gears and talk a little bit about not limitations on powers, but obligations that government has to protect public resources. segue into a discussion of the National Environmental Policy Act, which is kind of the organic federal law on environmental protection, and then say a little bit at the end about common law remedies. What do we argue when we go to court to protect the environment? So in terms of separation of powers, we have a system where powers are separated vertically and they're separated horizontally. Let's look at the vertical separation first. The general government power to regulate what we today call the environment inheres in the state governments in the United States. That general power is called the police power, and it's defined as the fundamental right of government to make all necessary laws to protect the welfare, safety, and health of the public. There's really no question of the power of the state or of local municipalities, which are subdivisions of the states, to enact what we term environmental laws today. And there's actually a lengthy history stretching back to public nuisance laws and smoke control ordinances that predates federal activities by over 100 years. Our federal government is a government of delegated and limited powers. And if you look through the federal Constitution, you won't see anything about a police power in there. That's not one of the powers that states delegated to the federal government when the federal government was established in 1789. How then has the federal government been able to achieve such a premier role in environmental regulation? You have to look to a couple of key provisions of the Constitution to answer that question. And those are the Interstate Commerce Clause, U.S. Constitution Article 1, and the Supremacy Clause, Constitution Article 6. One of the powers that the states delegated to the newly established federal government was plenary power to regulate interstate and foreign commerce. This is a power that is not shared between the states and the federal government. The states completely gave it up and they handed it over to the federal government. When the first modern environmental consciousness emerged in the 1960s and political pressure built for the federal government to act, the foundational laws that were in response to that pressure were and are based on the Interstate Commerce Clause. There has to be a nexus between commerce and the subject matter that the federal government is regulating, and I think we can see that that's obvious in the case of environmental protection, air pollution, water pollution, regulating the introduction of potentially hazardous substances into the marketplace, regulating the treatment, storage, and disposal of toxic and hazardous waste, regulating the cleanup of hazardous waste, all impinge on and have to do with interstate commerce. And the courts have been quite liberal over the past 80 years or so in interpreting the power of Congress under the Interstate Commerce Clause. It's been interpreted very broadly and in a manner that allows the federal government quite a bit of latitude to enter the field of environmental regulation. But there are limits, and next week we will explore some potential limits to that power. Most recent manifestation is the revised Waters of the United States rule, which actually reflects a school of thought which considers that the Interstate Commerce Clause power is not as broad as has been interpreted over the past few decades. The Supremacy Clause provides that the U.S. Constitution and laws passed under the Constitution, federal laws, are the supreme law of the land. And next slide, please. Let's stay with this slide a minute. Let's just one moment. The supreme law of the land. So what this power does is it, in some contexts, limits what states can do under their police powers to protect the environment. And there's a number of different ways that those kind of limitations manifest themselves, where a state law conflicts with a federal law, such that the regulated entity can't comply with both. The federal law preempts the state law. There's also a doctrine which says that even where Congress has not acted and there is no federal law, state laws can't be passed that would impinge on the theoretical power of Congress, the plenary power of Congress to regulate interstate commerce. Very good example of that was the Supreme Court case of Philadelphia versus New Jersey, which invalidated a New Jersey law which limited waste that could be disposed of in New Jersey landfills to municipal waste that originated in New Jersey, and banned and forbade out-of-state shipments of waste. The Supreme Court ruled that was a form of economic protectionism that was in contrast, clashed with the Commerce Clause, and it was invalid. So there are limitations to what states can do because of the Supremacy Clause. Let's go to the next slide. I'm kind of zipping through this stuff. It's in a way, it's kind of like 7th grade civics, but I want to, pause and give you some examples of how this does tie to environmental protection. In addition to horizontal separations of powers, we have, in addition to vertical separations of powers, we have horizontal separations of powers between the 3 branches of government that we're all familiar with, legislative, executive, and judicial branches. So what are the hot button issues in this area of constitutional law that might have something to do with environmental protection? As we all know, what Congress does is pass environmental laws of a general character, laws which announce goals, which in some cases establish deadlines, which in the main direct agencies to write regulations to implement those laws. And we frequently find that the directions that Congress gives are so general that the agencies have perhaps not unfettered discretion, but certainly assume an outsized role in prescribing regulations. Now, what does that have to do with a discussion of separation of powers? The legislative branch cannot delegate its powers to the executive branch. This is called the non-delegation doctrine. So you have allegations when regulations are challenged that they go too far, that they are actually amount to lawmaking by executive branch agencies. And the courts, again, over the past 85 years or so, have been very liberal in their interpretation of agency discretion. The system that sets up, that's acknowledged and has been followed is a system that serves the cause of environmental protection quite well. We do know that the average congressperson doesn't have the time or the expertise to, write detailed regulations in regards to the subject matters that are covered by environmental legislation, and it's a wise choice to leave that up to agency experts to make decisions about, say, exposure levels to toxic substances. Nevertheless, there is a line somewhere between carrying out a law and supplanting it. And certainly the regulated community regularly raises that argument. It has been rejected historically over the past several decades. And there's a school of thought that judges rely on. It's called the Chevron doctrine. It's calls for special deference to expert decision-making by agencies. Now, that doctrine is being questioned by the current justices on the Supreme Court. Justice Gorsuch is a critic of the Chevron deference doctrine, and we may look for the courts to more carefully scrutinize agency regulations in the future to see if they exercise too much, agencies have exercised too much discretion. So the judicial branch is obviously hugely important in environmental policy making. Judges may eschew that role, but they play that role whether they like it or not. There are ways that they make their decisions which bear on whether regulations fly or not. Most environmental laws and most environmental regulations are reviewed under an abuse of discretion. That too could change. There's different schools of thought and amongst the judiciary, and there's other doctrines besides the abuse of discretion doctrine. There's the hard look doctrine, which applies actually to NEPA review, which is what we'll talk about. And there's all the way up to de novo review, which is a court doing its own fact finding. So I would say that settled judicial doctrine is in flux at this time. It's due to the changing characteristics of the judiciary. Just another couple of things I would mention real quick about judicial review. Obviously, the maybe not be obvious to most of the people listening here, but the concept of standing to sue is vitally important in the review of environmental laws and regulations, challenges to them, arguments to uphold them. The judges, the judiciary requires that parties in any court proceeding have a personalized stake in the outcome of the case, and that's called the standing to sue doctrine. And environmental groups, public advocacy groups have gotten by arguing that their membership has particularized injuries from improper interpretations of law or regulations issued in violation of law, or Conversely, if they have intervened in a case to uphold regulations and laws, they argue that their members have personalized injuries, and that gets them standing to sue. But that too is a judge-made doctrine, which may or may not survive in the form that it's been used for over the past, I'd say 40 years, since the Lujan cases. Manuel Lujan was a former Secretary of the Interior and the defendant in those cases. So I think that's about all I need to mention about judicial review at this time. I want to turn to one other constitutional provision. And next slide, please. I've been talking so far about relationships between different branches of governments and different levels of government. I've been talking about the power dynamics between those units of government, those branches of government. Now I want to turn and talk to the limitations on government power vis-a-vis individuals and private entities. By far the most important constitutional provision in regards to that particular subject is the Due Process and Takings Clause of the Fifth Amendment to the U.S. Constitution. This is a clause which applies not only to the federal government, but to state governments as well, through the 14th Amendment. The 14th Amendment made the first 10 amendments applicable to the states. Takings Clause says private property shall not be taken for public use without due process and just compensation. Of course, many takings are no-brainers. Government needs property for a new airport, a new port facility, or a new highway. It initiates a legal proceeding called a condemnation suit to take that property. The only real issue is how much do they have to pay. But there are situations where there's a takings or an alleged takings due to government activity that is not acknowledged. And those kind of situations are referred to as inverse condemnation cases. Some inverse condemnation cases are physical. There's a very famous case out of Oregon called Thornburg versus Port of Portland, where back in the late 50s, when jet travel began to supplant propeller travel, the airport operated by Port of Portland expanded its runways. They started landing jets there. Jet travel increased. More and more jets kept landing there. The neighbors, the noise levels in the neighborhood grew to, adjacent to the airport, grew to intolerable levels. And the neighbors sued, saying that their property rights had been destroyed by activities at the airport, and they won their lawsuit. So those kind of situations, they happen. They're probably fairly rare. Far more significant for purposes of environmental regulation are what we call regulatory takings. These are also inverse condemnation situations, but they do not involve any kind of physical invasion of property by government. They involve government regulations restricting what private owners can do on their property. Very famous case established the principle of a regulatory taking. That was Pennsylvania Coal Company versus Mahone back in the 1920s. The Pennsylvania legislature had passed a law requiring coal companies to keep pillars in their mine shafts to prevent surface subsidence, and cave-ins. The coal companies sued, saying that the regulation had the effect of robbing them of all the coal in those pillars of all value. The case went to the U.S. Supreme Court, and the coal companies won. The court ruled to yes, indeed, there was value in the pillars had been destroyed, and the cave-ins were just an unfortunate side effect that should be dealt with another way. There was a very famous dissent in that case, which argued that you can't just look at pillars of coal without looking at the rest of the stake. And over the years, the reasoning of the dissent by Justice Louis Brandeis became the predominant doctrine of takings jurisprudence. So today we have inverse condemnation by regulation claims arising primarily in wetlands regulations cases. I think it's obvious that if you're denied a wetlands permit, and aside from issues of mitigation and so on, just looking at the property itself, it's either a wetlands or it's something else. There's really not too much in between. So it is natural that those who cannot build on a wetland or other protected property may consider that their property has been condemned without compensation. And there's a string of cases involving wetlands that, in line with the thinking of the dissent in Mahone, focus on the nature of the property rights that are being invaded as a whole. So what these cases do is analyze whether a taking occurred by using a balancing test, in which the extent of the interference is the key factor. And if the court concludes that there is some reasonable remaining use in the property seized or regulated in this case, then it's not a takings and no compensation is required. If there's no remaining use, then it is a takings and compensation is required. That's a principle which was established in the case of Lucas versus Carolina Coastal Commission out of South Carolina in 1992. Justice Scalia wrote the majority opinion. So what kind of things do the courts look at to determine whether there's a reasonable remaining use? They look at the character of the property. They look at the owner's expectations, reasonable investment-backed expectations, and they look at the nature of the government action. And I guess the key that I would leave you with to here is that they look at each case individually. These are ad hoc reviews. There's nothing more general than the factors I've just given you in deciding these cases. I think it's fair to say, though, that courts are quite liberal in finding reasonable remaining use. As recently as 2017, in the case of M-U-R-R versus Wisconsin, the court ruled that there had been no takings when one of two contiguous lots was denied a construction permit within a protected area along the St. Croix River in Wisconsin. And I'll spare you the detailed analysis in that case, but basically the court looked at the history of the property and concluded that there even though you couldn't build on the one lot, the other lot was contiguous, and the two lots could reasonably be viewed as one. So even local law and state law won't necessarily determine whether or not a takings has taken place. This is of significance, obviously, because if we have to pay people to refrain from destroying aquatic resources, we are not in a position as a government to do that. There has to be some ability on the part of government acting out of the police power, or in the case of federal wetlands regulations under Section 404, there has to be an ability for government to carry on and achieve public goals without having to pay people every time a right is infringed. You really have to have a property right that was destroyed. So I want to turn now to, I'm really going through a lot of this fast. I want to turn now to a discussion of the National Environmental Policy Act, or NEPA. I mentioned that environmental consciousness was increasing in the late 1960s. You had a number of dramatic incidents, and there were, thank you for advancing the slide. I forgot to tell you to do that. I'm sorry about that. The response of the federal government was to pass a law governing what the federal government, how the federal government would consider environmental values in its own decision making. And this law was the first step toward the array of very powerful laws that we have today. But it shaped how subsequent legislation, both I would say it's fair to say both federal and state level legislation would decide about protecting environmental qualities going forward. The whole scheme of evaluating environmental conditions and evaluating alternatives and preparing understandable documents to explain the analysis and inviting public participation, all of that, we see that reflected in many laws, but it stems from the National Environmental Policy Act. And of course, the act is still an important tool today. So I have to assume that many people on this podcast are familiar with NEPA as it has been implemented over the years, and I don't have to kind of review that too much, but I'll just say that the central requirement, which is environmental review through an EIS or another document falling short of that, stems from the section of NEPA which requires a detailed statement on the environmental impact of the proposed action, any adverse effects that cannot be avoided, alternatives to the proposed action, relationship between local short-term uses of man's environment and the maintenance and enhancement of long-term productivity, and any irreversible and irretrievable commitment of resources that would be involved in the proposed action. And that's language that's right in the statute. It's not derived from regulatory language. Those are statutory requirements. And the courts have interpreted this language as intended to require federal agencies to elevate environmental concerns to the same level as economic and technical concerns throughout the decision making by all federal agencies. The original regulations also require that you have something to say about what this detailed statement needs to consist of, and that's where we get the requirements that it be set forth in an understandable standalone document in lay language and reflect input and consultation with all relevant agencies, in addition to the analysis of the lead agency. So I think it'd be useful for us to review the recent revisions to the regulations. The last major regulations in NEPA were issued in 1978. That's a very long time ago. The Trump administration initiated a review and revisions to the CEQ NEPA regulations, which took effect. Their primary, I'm sorry, took effect is a little misleading. They were effective just about 3 weeks ago, September 14th, 2020. I should say that perhaps I should say those were finalized on that date. Agencies have a year until September 2021 to internalize these regulations, incorporate them into their own decision-making processes. Another salient fact I should mention is that these revisions are subject to review under the Congressional Review Act. It is conceivable, at least, that Congress will review these revisions and exercise a kind of a veto power over them. Nobody really knows, if that's going to happen. But what I want to leave you with is that there's nothing necessarily final about these final regulations. Having said that, let me run through some of the major changes from the 1978 rules that these regs have made. The small handle problem, the 1978 regs tended to be quite sweeping in determining what a federal project really was, and they focused on veto power. Even if federal permit was one of 20 permits that a project had to obtain, if it couldn't go forward without federal approval, it was considered to be a federal project and triggered the statute. The revisions revised the definition of a federal action, a major federal action. It has to be not only a federal action, but a major federal action. These revisions have a set of categorical exclusions, types of actions which will automatically not be considered major federal actions. And they include non-discretionary decisions, non-federal projects with minimal federal involvement, general revenue sharing with no discretionary control on the part of the feds, some loans and guarantees, which I'm not familiar with, frankly, and extraterritorial actions, which affects entirely outside of the U.S. So this kind of minimizes the small handle problem by excluding a lot of actions which might otherwise have triggered an EIS requirement. Another thing the revisions do is provide different definitions of major federal action and significant federal projects. The 78 rules kind of treated those terms as synonymous. The revisions under the revisions, major pertains to the nature of federal involvement, significant pertains to the impacts on the environment. There's, in terms of impacts, the 78 rules have a laundry list of impacts that should be considered in order to determine whether there's a significant environmental effect. You may be familiar with them. The 2020 revision gets rid of that laundry list and substitutes the language short and long-term effects and beneficial and adverse effects. Arguably, this vaguer language may incorporate those prior factors just ipso facto, but it remains to be seen whether there's going to be a narrowing of the range of factors considered under these revisions. Another major change is that the action, the new rule clarifies that action, the impact of an action refers to the affected area. There's a geographic narrowing of the application of the term impact in the new rules, and this I think this may have some effect on so-called programmatic EISs. There may be a move away from considering interconnected impacts under these rules, and there's other language which also supports that kind of interpretation. There's some housekeeping requirements which may that are new, which may further limit the scope of review. There are new page limits on environmental assessments and EISs. 75 pages for an EA, 150 for an EIS, unless it's complex, which then is 300 pages. And then there's time limits, presumptive time limits. EAs 1 year, EISs have to be issued 2 years. So those can be extended. Those are because they're presumptive. There's language in the revisions about pre-NOI investigation and fact gathering, which tends to, I think maybe counterbalances these time limits I've just explained. The NOI triggers the time limits, but if a lot of groundwork has been done beforehand by the agencies, then there's a possibility of getting a comprehensive work product out of the process. Nevertheless, there's some impacts on public comment. There's going to be strict enforcement of time limits for those, and there's language in the revisions about avoiding duplicative comments, I want to turn now to the EIS itself, the content of the EIS. The major change there is that under the old rule, effects are defined as the full range of effects, including direct and indirect effects, cumulative impacts, conflicts with local requirements, environmental and energy conservation impacts, and urban effects. And the old rule required consideration of connected, cumulative, and similar actions. The revision does away with all of that language and just requires consideration of effects that are reasonably foreseeable and have a reasonably close causal relationship to the proposed action or alternatives. A lot vaguer, perhaps much more narrow. We'll see how it plays out. Many people have wondered if that precludes consideration of climate change impacts. The final rule concedes that climate change can be and trends can be considered as part of baseline assessments. But the climate change impacts of proposed projects apparently are not to be considered in the under the language I've just given you as because they're supposedly not reasonably foreseeable or have a reasonably close causal relation to the proposed action or alternatives. I think that language probably will be litigated. Speaking of litigation, there are lawsuits already challenging these changes. It's far from clear whether these revisions will ever truly take effect. One of the lawsuits, I just have to mention this parenthetically, one of them challenges the rulemaking on the grounds that the rulemaking itself did not comply with NEPA. The impact of the new rules themselves was not considered. That's rather novel but interesting. Just in terms of the legal impact, of course, NEPA has been ruled essentially a procedural statute by the courts. Challenges have to do with following proper procedures. The projects themselves that are subject to NEPA are not actionable due to anything in the NEPA process. That might be challenged on other levels, but NEPA itself is not does not have any substantive standard that courts can look at. Just to wrap it up here quickly, I want to talk about environmental protection under common law, and I just want to very quickly mention the most common theories that are used to challenge environmental situations, unfavorable environmental situations. These are all varieties of what we call tort theories. Torts are legal wrongs. These are called common law theories because they are judge-made theories. These are not statutory theories. By far the most common tort theory in common law is the nuisance theory. And nuisances can be public nuisances or private nuisances. And a nuisance, what is it? It's a unreasonable interference with the use of, in the case of a private nuisance, private property. In the case of a public nuisance, a public use. State attorneys general often use public nuisance theories to challenge ongoing pollution or other unacceptable environmental situations, particularly where there's no clear statutory remedy. And you often see lawsuits where a nuisance claim is put in supplementary to a statutory-based challenge. Trespass is very closely related to nuisance. It's defined as the interference with exclusive possession of property. Modern courts have ruled trespasses can be from environmental influences such as sound waves, particulate matter, things of that nature. Negligence is breach of duty of reasonable care. And the main difference between nuisance, trespass, and negligence is where the evidence lies. The issue in a nuisance trespass case is the impact of the conduct, not the rightfulness or the wrongfulness of it, but how much damage it's done. And the plaintiffs are usually in possession of that knowledge. In negligence, the idea is that somebody has breached a duty of care. Somebody has been negligent. Somebody's done something wrong. That information is typically in the possession of the defendant. The plaintiff has to go and get it. And negligence cases are much, much harder to pursue. But we find them like in oil spills and other environmental litigation because the damages that you can obtain in negligence cases are significantly higher. They involve injuries to persons as well as property. And you can strike gold using negligence theories. Strict liability that's basically no fault liability. It's relatively rarely applied, but the shorthand for that, it's the right thing in the wrong place. That's what abnormally dangerous activity means under this. It's kind of eliminates the number of the different hurdles that plaintiffs have to jump to prevail in a tort suit if you can establish that the activity is classified as abnormally dangerous. The right place in the wrong time. It could be endangering a water supply where water is very rare, carrying on demolition in the middle of a city and somebody's injured from that. There's a number of different examples. Okay, I've gone on too far. I'm done.
Mark, this is Andy.
Yeah.
Thank you for your in-depth introduction to all of this. We do have a couple questions that are appearing in the chat, and I'll go ahead and repeat them. And we have about less than 10 minutes here, 5 minutes to get some answers to these, and then we'll wrap it up so that we're under our hour. The first question, how do you see the environment regulations and policies changing in the future to accommodate for climate change? And how often are these reviewed and updated at local and federal levels?
Is that one question from
Yes.
Brooke?
Yep.
Certainly policies are changing primarily at the state and local level. In terms of the national level, there's been a series of court decisions rejecting EISs because they inadequately analyze the impacts of the projects on climate change. Now, I just got done telling you that the consideration of climate change impacts is basically being eliminated under these new 2020 rules. I don't think that revision is really going to stand up in court. It's contrary to a string of decisions. And if you recall the language I gave you, the statutory language about what the detailed statement has to include, it's pretty hard to think that climate change should be excluded from that. So I think that I look for NEPA to continue to have an impact on on climate change. Just also, not to go on at length, there have been attempts to use the Clean Air Act to address climate change through President Obama's Clean Power Plan, and that plan was withdrawn, and a plan was substituted by the Trump administration. However, the Supreme Court has ruled in 2007 under the Massachusetts versus EPA that the federal government has an obligation to under the Clean Air Act to regulate greenhouse gas emissions. And the Trump administration has not challenged that ruling. So there is an obligation, which I think is far from having been fulfilled, a legal obligation on the part of the federal government to act. And so I see that there's going to be litigation in the future forcing the federal government to act. One thing I could talk about for another hour is how policies are actually, federal policies are actually achieved. 90% of them are achieved through lawsuits. So I'd look for some lawsuits to implement the 2007 court decision. I hope that helped.
Thank you. If you had to make changes to NEPA to make it more effective, what would they be? I
haven't thought too much about that question, but one one thing that's always puzzled me about NEPA is that there is language in the law which seems to suggest that if you do an EIS and the EIS says, there are going to be serious and irreversible environmental harms from this project, whether it's a new superhighway or a new, dredging out a new harbor or a new military base or any of the huge infrastructure projects the government might do, then the agencies are free to ignore those conclusions and go ahead with the project anyways. Courts have ruled almost from the very beginning of the law that that the actual project can't be stopped just because the EIS says it's a bad idea. And I say it's puzzling because if you look and you read at the law, it's going to suggest strongly that projects like that shouldn't go ahead. So I don't understand why. I've never quite gotten the reasoning of courts that say, this is essentially a procedural requirement. Having said that, there is merit in the procedure, and I could go on and on about that too.
Mm-hmm.
But the whole idea of mitigation, those are good things. We shouldn't try to minimize the good that comes out of it.
We'll wrap it up with one last question from one of our employees here. Do you have any recommendations for resources to review for someone relatively new to the environmental law and policy litigation realm?
If you mean like to study?
Correct.
Okay. Well, I'm gonna do something here. I'm gonna recommend this book. Is it backwards in the?
Nope, it looks good.
All
Environmental
right.
law and policy.
This is the textbook I use in my environmental law class. James Saltzman is a highly respected figure in environmental law. The reason I would recommend it to somebody relatively new, my students are relatively new, and they seem to get a lot out of reading this. But this is very easy reading for the non-specialist. In fact, it's so easy that I supplement it with harder reading to challenge the students more. But this is quite easy to read, and it gives you a good overview, and you can use it as a basis. There's a lot of references in it. You can use it as a basis for more intense study if you want to carry it that far. So yeah.
Perfect. Thank you. All right, well, with that, we're right at noon. Well, noon here in the Central Time Zone, 1 o'clock for those of you on the Eastern Time Zone. Thank you, Mark, for the great conversation today. Everyone who's attended, I invite you to send any follow-up questions to me at acooper@ect.com, and we'll get those to Mark. And then reminder, we have a follow-up lecture number 2. It'll be same time, same place, and next Friday. So we look forward to seeing you there. The topic is the Federal Clean Water Act. And lastly, for anyone interested in continuing ed credits, if you go to the source on the right-hand side, you'll see a button you can click and just register yourself with a quick form. And at the end of this series, we'll send out to you a certificate you can use to put time towards your continuing ed hours.
Andy, if I could just interject. Yes. This book, in case you couldn't read the title, it's Environmental Law and Policy, 5th edition by Saltzman and Thompson, Foundation Press.
Excellent.
Okay.
Thank you very much. Okay, well, with that, thanks everyone. Reminder, this was recorded. So again, we'll have this up on the source as a resource for everybody in the future. Mark, thank you very much. And we look forward to seeing you next week.
Thank you.